For those intrepid members of the audience who are still plugging through this long day, we have a roundtable panel. It's going to go from now till 5 o'clock, a little bit shorter than as advertised. And afterwards, we will be adjourning to the rotunda for reception with the panelists and some cheese and crackers and refreshments. And you'll get to ask people one-on-one all the questions that are burning in your minds. But before we get to that, my good friend Don Ferencz, who is the director of the Planethood Foundation and whose foundation has been supporting the work of our students who do war crimes prosecution work all around the world, and whose foundation also supported this conference, is going to be moderating this panel. Don has no resemblance to Ben Ferencz, so don't think that they are related in any way.
Use that same joke last year.
I don't know. But Don, in his own right, has become quite the expert at the International Criminal Court, and this conference was his brainchild. So thank you, Don, and thank you, panelists.
Thanks very much, Mike. And by the way, after Mike's comment last year that I was not related to Ben Ferencz, I thought maybe he knows something I don't know. So I went and I talked to my mom, and it turns out you're absolutely right, Mike. She confirmed the whole thing. I'm delighted to see that we've got a good audience here, because I think this is going to be a very interesting discussion. There is, as far as I'm concerned, a loophole in the Rome Statute that is a mile wide, which basically says, who cares if we put aggression in the statute, because it doesn't need to apply to anybody. And we'll come to that in just a moment. What I'd like to do is just take a minute to reintroduce some of our panelists, and then what I'm going to do is introduce you all to the very brief section of the Rome Statute, which I'm going to read, that we're going to be focusing our discussion on. Cherif Bassiouni, you met earlier today. Roger Clark from Rutgers. I don't know whether you had been introduced earlier today. We have Astrid Reisinger Coracini, who is a lecturer from Graz, Austria, who's with us today. We have Stefan Barriga, who I think some of you may have met today from the Lichtenstein mission. And all of these people have been very intimately involved with the crime of aggression. Some of them currently working now with the working group. Others have been working on this problem since Rome. The things that we're going to talk about are going to be the sections of the Statute of Rome dealing with the procedure by which a provision on aggression will be included in the statute. And I'm very careful not even to use the word amendment yet, because you haven't heard from Roger Clark, and I'm very, very careful in Roger's presence to use these words very cautiously. We're then going to talk about what are the implications, both for states parties as well as non-states parties, currently and also prospectively. That is, what might the impact be of adopting a provision on parties or countries who are not currently states parties, but may be in the future. So with that, I'd like to just get into Article 121, which you actually heard referenced in the last panel. I'll have to tell you what everybody was talking about. Article 121 says amendments. And there are various paragraphs, subparagraphs. I'm going to read you three of them, 3, 4, and 5. 3 sets forth a rule that says, quote, the adoption of an amendment at a meeting of the Assembly of States Parties or at a review conference on which consensus cannot be reached shall require a 2/3 majority of states parties. Simple, easy. We can listen to it once and we all have got it. Now comes 4. The first word I want you to listen very carefully to, except. Except as provided in paragraph 5, which I'm going to read you, an amendment shall enter into force for all states parties 1 year after instruments of ratification or acceptance have been deposited with the Secretary General of the United Nations by 7/8 of them. So it states a general rule for effectiveness of an amendment. General rule. But it alludes to an exception. Now we come to the critical exception to the overall general rule. Paragraph 5. Any amendment to Articles 5, 6, 7, and 8 of this statute, and you'll all recall 6, 7, and 8 dealing with the other core crimes. 5 is the one we're talking about today. Any amendment of those core articles shall enter into force for those states parties which have accepted the amendment 1 year after the deposit of their instrument of ratification or acceptance. In respect of a state party which has not accepted the amendment, the court shall not exercise its jurisdiction regarding a crime covered by the amendment when committed by that state party's nationals or on its territory. When I said a moment ago that the Rome Statute has a provision which is a loophole you can drive a truck through, I was being actually not exaggerating. You could drive a whole fleet of trucks through it, it seems. Now, with that as the backdrop, what I would like to do is really turn it over not only to our panel, but if there are those of you, since this is a round table, we have a semi-round room, if anybody has a burning issue that they'd like to throw in rather than simply wait for, quote, questions, please feel free to raise your hand, and if there's an appropriate moment, I can interrupt and we can either take the clarification question so everyone will understand what we're talking about or hear a point. With that, Cherif, I turn it over to you for your thoughts.
Well, I think history is usually a good reminder of what can and cannot be done. And I'm sure you'll all recall that shortly after the end of Nuremberg in particular, the General Assembly adopted a resolution in 1946 embodying the Nuremberg Principles. Subsequent to that, the General Assembly established a committee to develop a code of then called offenses against the peace and security of mankind. It was quite clear within a short period of time that this code, which was going to include basically crimes against peace and aggression as the first crime, was not really going to fly. And so you saw a very interesting procedural bureaucratic mechanism of first splitting the issue of the court from the code and having a separate committee looking into it. And when that committee produced the text in 1953, it was not acted upon because the code had not been prepared. Then there was a separation from the draft code of the issue of aggression, which went to another committee. And when the draft code was submitted without the definition of aggression to the General Assembly in 1954, it was tabled because aggression was not defined. When aggression was defined in 1974, Resolution 3314, it took 4 years for the General Assembly to have its feet to the fire to recognize that it's time to go back to the code and to the court. And what the General Assembly did is remand it to the ILC. The ILC took jurisdiction in 78, and a special committee headed by Mr. Dudu Thiam, who was the best guarantee that nothing would have been achieved, dilly-dallied until almost 1994. By 1994, it was evident that the Security Council had taken an entirely different track by establishing first the Commission of Experts, then the ICTY, then the ICTR, and a whole new track opened up. Now, having said that, the point remains that there was a decision made, I would say, quite early on in the ad hoc committee, the preparatory committee, and then in Rome, that not all international crimes would be included in the jurisdiction of the ICC, that we were going to include only the major crimes. And so terrorism was excluded and drug trafficking was excluded, which in 1989, as you recall, was proposed as the basis of an international criminal court by Trinidad and Tobago. So there was consensus on these three crimes, but there was consensus subject to priority in national jurisdiction and subject to a role by the Security Council. So in a sense, if you want to look at the pillars here, the pillars is consensus and agreement on these crimes. It's not to say that the other crimes are less important or trivial or whatnot, but that's where the consensus was. Do not, in a sense, perturb that consensus by adding other crimes for which there are going to be issues raised, including political issues as with aggression or political issues as with terrorism. Let's keep it as pristine as possible. So that was one pillar. And the second pillar was that having done so, there has to be a recognition of the role of the Security Council, ergo Article 16, and the ability of the Security Council to refer the situations to the court. Now, there was a great deal of effort to include aggression, and the argument was really the same argument we heard today by Ben, and that is, if you don't include it, is that an implicit repudiation of Nuremberg and Tokyo? Is that rolling things back? Is that sending a signal to states? Is that sending a signal to the Security Council? And so the compromise was made, well, all right, let's refer to aggression as being part of the jurisdiction of the court, delay the definition, maybe in the hope of never defining it at all, so that you have the symbolic presence of the word aggression in the statute, but never really getting the court entangled into the politics of making it work. And there's great merit in what Mark said today. If you want to make the court work for a period of time, adding to it what Elizabeth deducted from the block-by-block building of the Temple of Justice, maybe this is not the right time for aggression. Maybe aggression should be kept the way it is, reinforce the court, see what its jurisprudence is, see what its track record is, create greater coalescence around its jurisdiction as it stands now, and get back to it when the time is more propitious. Pushing it through as it goes now, and here's where I come back to where Don was saying, pushing it through as it is now means that Article 124 and 5 will apply. States that do not want to accept it will not accept it, and therefore its nationals will not be subject to the jurisdiction. So now what you have a piece of Swiss cheese which is full of holes. You have the hole for those who have opted under 121.5 not to agree to it, and therefore they're excluded. So you'll constantly have to have a little book with you with the list of the 106 or 110 countries. This one agreed, this one didn't agree, and so on. And then you're going to have other little holes in that nice piece of cheese. Whatever triggering mechanism is going to be adopted, whether it's the Sheffer formula or another, these are a few little holes there in terms of political discretionary power. Then you're going to have a few other holes that deal with the actual definition of the crime, and finally its application. So the question is it better to have a piece of Swiss cheese with a lot of holes in it, or to eliminate that and simply have the aggression stay in under Article 5, dangling there for symbolic purposes and awaiting the ripe time for it to come back into the picture? My concern is, and I'm sure Ambassador Christian and others who have worked very close to it, there is no way that a significant role for the Security Council will be avoided. And if that happens, half of the state parties and other non-state parties will reject that by saying, well, you see, this is proof that it's politicized. So all of that put together, I think what we ought to do is, in a sense, take a step backward and sort of reassess the utility of pushing forth at this point with something that may not be as good as what we want. And if we accept that something which is not as good as what we want, will it have more detrimental consequences than positive consequences? Can we, in some alternative ways, reinforce the symbolism, the past, not break faith with the past, lay the foundation for the future in a way that keeps us away from the Swiss cheese?
Now, before we turn it over to Roger, I'd like to just quickly react and ask a specific question. Obviously, Cherif is talking a little bit off point relative to our panel's description today, and I want to bring you back to a specific question before we hear from Roger, and it's this. The provision that I just read was quite specific. It said if you amend 5, 6, 7, or 8. Would you have a particular view if the working group took it upon itself not to amend Article 5, 6, 7, or 8 and tried to take another route around the application of 121.5? Would you have any reaction based on your knowledge of the intention of the Rome Statute and the way the statute is crafted as to your reaction to such an approach? In other words, an approach which would perhaps bring into question whether 121.5 even applies. I'd like your reaction to that before we move on.
You know, legal imagination has no bounds. One can certainly think of saying that because Article 5 preconizes the establishment of a definition for the crime, therefore, this is not an amendment.
Thank you.
You know, how that will withstand legal scrutiny is doubtful. Which means that any way you look at it, it may not be an amendment in the traditional sense of changing the existence of a text. It is an amendment insofar as it adds something to the existence of a text. And if it adds something to the existence of a text, it is subject to the opting out provision that we have in 121.5.
Okay, fair enough. Thank you. Okay, Roger.
Yeah. I often feel like the designated spear catcher on these occasions. They put me up on these panels. The guy who comes before me dodges the issue that the chairman wants you to talk about. And then he says, Roger. So here I am.
Don't be afraid, there's also Astrid behind you.
Yeah, all right. I know I've got some support here. And actually, in Graz, there's the most wonderful collection of spears and other instruments for killing people. So I know Astrid has thought about these kind of analogies. Myers McDougall, Biel, has a great piece in the 1940s where he asks whether law professors are training people to be Pericles or plumbers. This is Pericles. I'm a plumber, and I've been reading this statute and indeed trying to draft it. Cherif was the chair of the drafting committee. Cherif, when was the first time you saw Articles 124 and 125 in their present shape?
I think 2 days before the final text was submitted for approval.
Impossible, because the text was changed after the conference and added the words 6, 7, and 8 after 5. But he saw them earlier than I did, and I was one of the two people who was in charge of the negotiations that led to this. And the last time we saw it was on July the 11th. The next version we saw of it was on the 17th. Actually, fairly early on the morning of the 17th, the last day of the conference, we saw it in its present shape. I mention that because our friendly chair said to me, what was the intention of the drafters? God knows what the intention of the drafters was, because, and I can assure you that the working group that had worked on it for several weeks of their time in the Roman summer didn't produce it quite this way. They produced 4 essentially the way it is, and 5 had 2 lots of brackets, a big bracket all around it and a bunch of brackets inside it. Let me back up and see if I can...
Can I just add a little?
Yeah.
Note? Because you had the brackets, the drafting committee interpreted that as giving it discretion to remove the brackets or change the contents, ergo a text that is somewhat different from what your working group did.
Well, thank you.
Now you tell them.
It was really nice that somebody came back and told us what we had wrought, except leaving us to the find of the hard way. But look, let me look at the Pericles problem here. You're drafting a multilateral treaty. In particular, you're drafting a multilateral treaty that's the foundation constitution of an international organization, a constituent instrument. And you say to yourself a number of things. Are we going to have reservations? Are we going to let some people opt out by the reservation process? And we fought that long and hard. And the treaty says, no reservations. Although the French, on that last day, long after you saw it, managed to get in Article 124, which enabled them to opt out of the provisions dealing with war crimes for 7 years. They just removed that declaration under Article 1.4, but for 7 years they've said we reserve the right to do war crimes. They and Colombia got that deal. Now, no reservations with that little exception. In addition to that, at an earlier stage of the drafting, in relation to the crimes under the statute, which at some drafts included drugs and terrorism, you could opt in some versions, or you could opt out. There's a list, the Chinese menu approach, you take these ones if you feel like it, or you can say, we're against genocide, and the idea was that everybody would say they're against genocide, but you can opt in for the other crimes. Pick your crime, and so on. Well, that disappeared, and it disappeared along the way. But I mention all that because there's a second bunch of questions that we have to ask now, which is how do we fix this? Where do we go once we understand what the mess is? And I think our chair has got the mess fairly well. As I read Article 121, paragraphs 4 and 5, they're clear alternatives. You can have one or the other. The only question is what applies to which situation. Now, I know there are others, and the diplomatic mind sort of elides them, and Cherif started doing that at one point. You can't do that if you read it. Now, the Vienna Convention on the Law of Treaties says ordinary meaning in context. And the ordinary meaning of that, I can assure you, whatever sense you make of the history of this up to July the 11th, was that these were alternatives. Now, let me read you something else. Because, as I say, the Vienna Convention says in context. And part of the context is Article 5 too, is it not? Because this, which was introduced by the non-aligned group on Bastille Day 10 years ago, July the 4th, they introduced, what became this? It got amended somewhere. The unseen hand who does these things. July 14th, I'm sorry. Did I mix it up with July 4th? Yes. Oh, perish the thought. July the 14th, it was introduced. And you'll notice that paragraph 1 has the crime of aggression within the jurisdiction. And 2 goes on, the court shall exercise jurisdiction over the crime once a provision is adopted in accordance with Articles 121 and 123 defining the crime. Now, as Bill Clinton said, it depends what you mean by sex, doesn't it? It depends what you mean by once a provision is adopted in accordance with. You can parse that, and it's not the most brilliant piece of plumbing. Believe me, it's very difficult to know what that means. But to my mind, it does not refer to any amendment to Article 5. You do not need an amendment to Article 5 to deal with the provision adopted for the crime of aggression. Indeed, the only time the word adoption appears in Article 121 is in paragraph 3. Don't get me down that road, because that freaks people out. The thought that all you have to do is run it through the Assembly of States Parties, but adoption must mean something different. In context, it must mean something different in 5.2 and 121.3. At least that's what most of the world tells me must be the case.
Roger?
Yes.
I'm sorry, I'm genuinely sorry to interrupt you, but Michael handed me a note.
And he said?
I'll tell you what it says.
Yeah.
It says, Don, please announce as soon as you can. And that's a challenge, because I'm really not wanting to interrupt what you're saying. But that we are circulating a Cleveland Declaration drafted by Ben, Cherif, and Michael, which recommends that the Assembly of States Parties adopt a definition, notice the word adopt, by the way, a definition and trigger mechanism for aggression in 2010. So that's what Michael has been handing out here to try to distract our audience, because he envies the good points you're making.
Thank you.
I would like it, if you could just continue exactly where you were, and I do apologize.
I'm not going to go on for too long.
No, but it's an important point.
Yeah, I think it's important to get these issues out on the
That's why we're here.
table, because there's a real question about what it means. Might I add this? Again, it's to go back to the question about an international organisation and a constitution thereof. By and large, you want to have everybody on the same page, do you not? I mean, that makes sense. If you have a UN, you have a provision in it that says if you want to amend it, 2/3 of the existing membership has to come aboard, including the P5 in that instance. We have a slightly different rule in 4, which is designed to get everybody aboard. Now, 7/8 is very difficult to get, and that was hard bargaining that ended up in the end with that. Article 122, just to complete the picture, makes it possible to make amendments of an institutional nature, certain machinery stuff, without going through that 7/8 process, or without going through the paragraph 5 process, because you've got to be able to fix some things, like the number of judges and some of the conditions under which the thing operates, so you get to that position. Now, if I'm right, that the statute says that you got to get 7/8 on the crime of aggression, and I believe that's what it says. The plain meaning is what it says. Then you ask yourself, can we fix this retroactively if we want to? If we decide that we don't want to do that, can we get a fix?
Roger, I just want to stop to clarify for the audience and also for myself. I think I've heard you say thus far that you don't believe that 121.5 applies because we're not talking about a, quote, amendment. Is that what I'm hearing you say? And therefore we're in
Well, I think my argument is not an amendment to Article 5.
Okay.
See, it's like sex. Amendment is a word that sort of slides on you in this context, unfortunately. And my argument is this is not an amendment to 5, 6, 7, or 8.
Okay.
It's clearly not an amendment to 6, 7, or 8. That's easy.
That's easy.
Because they deal with other crimes. So the only question is whether it's amendment to 5. And David Sheffer says, well, amend 10, put it in there. The chairman's proposal is to have 8 bis. We've got to amend 15. We've got to amend 23. There are amendments to various parts of the statute.
So just again to clarify for everybody, you're saying it's not an amendment, therefore 121.5 doesn't apply.
No, I'm saying it's not an amendment to Article 5.
Article 5.
Right.
Okay.
It's an amendment. I'll concede
It's an amendment,
that.
but not
You've got to
5.
use the amendment procedure in that sense because it refers you.
So that's what brings you out of 121.5.
That is correct. Now, assume I'm right, and assume, for some reason, that you want to do it differently. You want to have an opt-in, an opt-out, or something of the kind. Can you fix it? A nice question, isn't it? We've now got a treaty in force that has an amendment procedure, and does the amendment procedure for Article 121.4 apply to amending Article 121.4, if that's what you want to do.
So
a good question.
And you're suggesting that 121.4 needs amending because the 7/8 threshold is too high? And
No, I'm not suggesting that for a moment.
Well,
I'm
that's what I'm
raising the
asking.
question as if you decide that's what you want to do.
Why would we want to?
Because there are those who say the only way we're going to get this is if we make it totally opt-in.
Okay, in other words, if we're not in 121.5 because it's not an amendment to 5,
Right.
we may still need to follow the logic of 121.5 anyway, and therefore we need
if
to
you wanna
amend
do that.
121.4.
As I say, it's
Just
a
want
nice
to make
question.
sure we don't lose too many of us along the way.
It's a nice question, as I say, whether you can amend it by some procedure later on. Now, the only precedent I know of, actually, is the great fix for the Law of the Sea Treaty, the Montego Bay Convention, which you'll remember the same arguments arose. We want universality, so we need to get a fix. And essentially that treaty was amended without being called an amendment. It was an implementation agreement. I think the jury's out on whether that was good law or not, but it was done, and there was a consensus of sorts about doing that. There may be other precedents, there may be other fixes. Of course, the fix to the Law of the Sea Treaty was done so that the United States would then ratify, and I'm happy to report the present president sent the treaty back to the Senate again. I suspect that he's not going to work on it in the next 38 days or so to actually get it out of there, so the new president will still be able to think about, what was it, 12 years ago the fix was arranged so that the United States could come aboard. But that's certainly a possibility. But anyway, I think that's the problem. We've got a problem which you identified. I think it's a real problem. I think it's a difficult piece of statute interpretation. I think we got there because think about drafting something like this with 160 countries participating in 6 languages in a situation where ultimately you don't know what's going to happen with aggression. And frankly, from our point of view, the small countries of the Pacific, you didn't know what was going to happen with nuclear weapons. We wanted them in there. The powers who had them were pretty certain they didn't want us to be able to amend the treaty in such a way as to put them in later. They thought we're up to no good. Probably true. We would have been very happy to amend it later if we could figure out how to do that. And that's a complicated problem. So it's against that background that you get this very difficult procedure and the 2 versions of the ways to go. Now, of course, the problem isn't as acute for those who just want anybody who becomes a party to it can do it, to say, well, what it really means is any amendment is an amendment to Article 5. I don't think so. And thank you.
Thank you, Roger. Now, before we turn it over to Astrid, the beauty of having a moderator who's not that bright is that I get to go and ask him again to tell us all why it's not an amendment. I mean, you spoke a little quickly.
Read the plain language.
So
the court shall exercise jurisdiction once a provision is adopted in accordance with.
Okay, so...
But wait. Any amendment to Article 5 shall enter into force. Where's the amendment? All you're doing is...
should be consistent with...
You're just simply following the instruction of Article 5. You want to exercise jurisdiction? Do this.
Well, yeah. But let me ask then, I want to ask Cherif a question. Are you persuaded by what he's saying? If you don't mind, because you've got a little more experience in this field than I do, and I'm curious for our audience to know your reaction.
Actually, can I add the question, Roger, did you explain it that way already in Rome?
No.
There was no opportunity to explain it that way in Rome, because we were stuck with this at the last moment. That's
Okay,
the point.
Cherif's turn.
Yeah.
Now, what you have to keep in mind that the process in Rome was a very difficult and cumbersome process. We had approximately 11 working groups working simultaneously, most of them without interpretation. They produced not completed text, but portions of texts. So the drafting committee would receive, for example, in the context of Article 121, maybe 121.1 on a given day.
No, we sent you the whole thing. You
But
got
I'm
a
just
whole
giving you an
package
example.
from us.
No, I'm just giving you as an example. We had numerous articles that came down in smaller provisions like that. So we had to put these together. And obviously, because of the press of time, what you had is some provisions that came in that were sort of more ready than others, with a greater consensus than others. So when Article 5, which were among the first provisions to come in, the reasoning, the logic was very simple. Aggression is accepted within the jurisdiction of the court. We need to define aggression. When aggression is defined, it is to be added to Article 5. At that point, looking at that question, nobody really thought, as I recall, is that going to be an amendment, or is that simply going to be filling the gap that could not be filled in Rome? By the time we got to Article 121, we also realized the higher level of sensitivity that many delegations had for anything that would change the language of the statute. And the feeling at the time was, we don't want anybody to be able to change the language of the statute other than within the context of an amendment procedure. That was the way that the state parties would have control over the textual language. And so if you look today at a distance at these two articles, you can come up with a valid interpretation, as Roger has given, about Article 5 in and of itself. But then if you look at 121, which comes later, you realize that this really qualifies the more liberal interpretation that you may give Article 5, reading it outside the context of 129. I am personally convinced that if for example, we have had other crimes, that terrorism or whatever not, and we would have said, subject to its definition in the future, that nobody would have come up with the conclusion that this is not really in the nature of an amendment that the state parties would have to approve. I mean, this is much too critical an issue.
Okay.
But certainly if you look at the way Article 5 was drafted in and of itself, in isolation, outside of context, and outside of 121, which came subsequently, you can come with the valid interpretation that Roger had.
Because of the time, I'd like to keep us moving, and then we'll circle back.
Could I just one point?
Yes.
And I will not say another word. Cherif's made my point. If you want to add the crime of aggression to this treaty, you need to amend Article 5. That's an amendment to Article 5. It's the only way you can do it. You've
Okay.
got to add to the list.
And that may happen.
It may happen, but you've got to do it by 7/8, because it's an amendment. You can't do it by 7/8. You can only do it by 5. You can only apply it to those who opt in under paragraph 5.
When you say you can only apply it, I don't know what you mean.
Well, assuming you
Yeah,
add
it'll only
terrorism,
be effective. It'll only be effective.
It'll
as to
only be
those who opt
effective.
in. I agree with you completely.
It'll only be effective to those who agree
Okay.
to it under paragraph 5.
Are we
I'll
ready?
say not another word.
Okay, well, that's an important point that you're making.
Yeah.
Because this is confirming what I said at the outset. There's a loophole in the Rome Statute that effectively, I shouldn't even call it a loophole, because it's not a surprise to anybody. This is the way it was intended to be drafted. This is not Swiss cheese. This is a huge, giant bridge that was built for everyone to ride under it, and it was all above board. Everybody saw it coming. Okay, with that, Astrid,
Thank
your
you.
thoughts?
Thank you, Don. I was already wondering, seeing the list of speakers, what was there left for me to say. But especially Roger Clark, he went through all the articles and gave his opinion. I mean, I would like to recall some of the legal arguments, trying not to duplicate, but maybe having a different view of some of them. So, when we talk about the crime of aggression in the International Criminal Court, I believe the starting point needs to be Article 5. And of course, I personally was not in Rome, but I'm under the scrutiny of persons who have been. And it has been mentioned today several times, the crime of aggression falls within the jurisdiction of the court. Aggression is under the jurisdiction of the ICC, according to Article 5, paragraph 1. Of course, the ICC cannot exercise its jurisdiction at the moment until a provision on aggression will be adopted. But I think this is the starting point, and many regulations of the Rome Statute particularly refer to the list of crimes in Article 5. And I'm thinking, for instance, in particular of Part 2, where we have Articles 12, Articles 13, the complementarity regime. They're all explicitly referring to the list of crimes in Article 5, and that includes the crime of aggression. And there's also Part 9, the cooperation, which refers to crimes under the jurisdiction of the court. And if we have a closer look at Article 12, paragraph 1, there we read that a state party, by ratifying the statute, has accepted the jurisdiction of the court according to Article 5. So I'm suggesting that every state party that has ratified the statute has accepted the ICC's jurisdiction over the crime of aggression, under the condition that at the moment it cannot be exercised. And once a provision on aggression will be adopted, there's also an argument that those state parties who have ratified the statute also are under obligation to cooperate with the ICC on charges of aggression, even if they choose, if there is a possibility to opt out on the exercise of jurisdiction over their nationals or their territory, if we agree on that. So I think this is my starting point. And of course, states are free to change the terms of the statute, and they could do so by amendment, or they could do so within negotiating the conditions under which the ICC can exercise its jurisdiction over the crime of aggression. But I believe at the moment we have these two starting points, that the crime of aggression falls under the jurisdiction of the court, states parties have accepted that, and in the future they might be under the obligation to cooperate with the court on the basis of this crime. So Professor Clark has already mentioned the different amendment mechanisms that are available in the statute. And of course, there are three of them, and one is clearly not applicable to the crime of aggression. That is Article 122, for two reasons. First of all, it's only applicable to regulations that are specifically mentioned in Article 122, provisions on a purely technical nature, and also Article 5, paragraph 2 does not refer to Article 122. On the contrary, it refers to Article 121 and Article 123. A provision on the crime of aggression that needs to be adopted. And Professor Clark has not gone in detail into the argument of what it might need. The possibility that has also been discussed in the special working group on the crime of aggression, that maybe all we need is a provision on aggression that has been adopted, and then maybe we do not need a ratification procedure. I think there's quite a clear sense in the special working group on the crime of aggression that this will not be acceptable. But I think it's an interesting thought, because it continues the idea that aggression is something that has not been finished in Rome, but it needs to be treated in the same way as the other crimes that are already under the jurisdiction of the court. It's kind of, there's no argument why you should treat it differently. Now, when we need to choose between one of the amendment mechanisms, Article 121, paragraph 4, or Article 121, paragraph 5, I think you can make legal arguments for both of them. I'm also more inclined to go for the application of Article 121, paragraph 4, and there are different reasons for it. And I think one that hasn't been mentioned yet is that there's a generous sense within the special working group on the crime of aggression that all parts of the provision on aggression will be submitted to the same amendment procedure. That means the definition of the crime of aggression, but also the provisions, the conditions of the crime of aggression, and all other changes that might be necessary to the statute. And I'm very much, I think you also mentioned this, the ICC statute is a founding instrument of an international organization, and I see tremendous problems if we would have changes to matters of institution that are only applicable to parts of the member states but not applicable to others.
Astrid, I want to interrupt you just to clarify for myself and the audience something that I think I just heard you say, which is that you feel that 121.4, which is, if you will, the general rule, ought to apply because there are other provisions in the statute that also will be amended, and the amendments of the other provisions in the statute and the amendment to Article 5 ought to be effectively effectuated in the same manner in the statute. Is that the point you were making?
Yes. I can go with submitting the whole package of the crime of aggression under the procedure of Article 121, paragraph 4. I cannot go with submitting the complete package under the provision of Article 121, paragraph 5.
Well, then let me ask you about 4. 4 is the paragraph that says it becomes effective for all states parties when 7/8 have deposited instruments of ratification. Is it applicable to no one then until 7/8?
Oh, yes,
so in
of
other
course.
words, if 6/8 deposit instruments of ratification, none of them are bound until we get to the threshold 7/8, at which time it's applicable to everyone, including those that did not deposit instruments of ratification?
Yes,
That's what it says.
I think there are positive and negative aspects.
And Roger told us that he thinks that that's not an approach that we should take, that we ought to conform.
No, I didn't say that. I said there are those who believe that.
Okay.
I'm very happy to follow that approach.
Okay, you're happy with 4 as is. I thought you said it ought to be sort of put on a parity in terms of an equity with 121.5, but I must have misheard. Okay. I'm sorry.
Oh, thank you. I think there are positive and negative aspects to applying Article 121, paragraph 4. Positive aspects would be universality, that we have all states parties being on the same track, and those that would not agree have a possibility to opt out, and I don't believe that there's a huge danger that too many states parties would leave the court because of that. Another possible aspect, and this is maybe coming back to what Professor Bassiouni also mentioned, that maybe it is a bit fast, and maybe some more time to accommodate with the provision on aggression might not be a bad idea. And if we apply Article 121, paragraph 4, there certainly will be some time until we have the 7/8 ratifications for the provision on aggression. So you have the negative side of having a delay in the application of the provision on aggression, but on the other side, maybe this is also not completely negative. Maybe it helps states to get used to the idea, to get accommodated with the provision and the definition and the conditions. On the other side, maybe there is one positive aspect also with regard to a possible application of Article 121, paragraph 5. And I'm not saying that there is no legal argument for the application of Article 121, paragraph 5. And that would be that states parties who wish to be bound by a provision on aggression earlier, they could do so. So, of course, Article 121, paragraph 5 establishes a system of 2 speeds. Of those states parties that accept an amendment, and then it's applicable only to them 1 year after they have deposited an instrument of ratification. But it also provides the ICC at an earlier stage with jurisdiction over the crime of aggression, certainly only in a very limited area. But one point I would like to make with regard to the application of Article 121, paragraph 5, and this is how it relates to Article 12 and 13 and the preconditions for the exercise of jurisdiction. And I believe that coming back to what I said at the very beginning, that our starting point is Article 5 and that the crime of aggression is already under the jurisdiction of the court, and that even if we opt for an application of Article 121, paragraph 5, what we would amend or add is the definition of the crime, but not the question whether or not the ICC has jurisdiction. I think there should be a point in not asking for any additional preconditions for the exercise of jurisdiction of the crime of aggression than those which are already established in Part 2 of the statute. And I also see a very practical problem if such preconditions would be established. And this is for, in particular, a Security Council referral, because the provision in Article 121, paragraph 5, does not distinguish between different trigger mechanisms, as, for instance, does Article 12. So the same preconditions for the exercise of jurisdiction arguably need to be established with regard to any trigger mechanism, also when the Security Council refers a situation. And I don't believe that this is an acceptable situation when you have a Security Council referral concerning charges of aggression, that then you would need to establish preconditions for the exercise of jurisdiction that would exceed the normal standard that is set up for Security Council regulations in the statute.
Yeah, just to back up a little bit, because everybody may not have Article 12 clearly in their mind. Astrid and I have had the following conversation preceding this panel. Article 121.5 says that if your country doesn't want to be governed by the law on aggression, if it does come within the active jurisdiction of the court, all you have to do is not deposit an instrument of ratification. And then what does the statute say? It says that the crime will not apply to your nationals or to what would otherwise constitute a crime if committed on your territory. So what happens if one of your nationals is deemed to have committed the crime not on your territory, you've opted out, but on the territory of someone who has ratified and thereby opted in? And this is the issue that is really underlying some of what Astrid is getting at, that the general rules which confer the court's jurisdiction on states parties as to their nationals or crimes committed on their territory is in conflict, actually, with the language of 121.5. So that's what she's getting at here.
Yes, I think I should stop. I'm filling my time. Maybe just one very short point also on that issue. If we understand the last clause of Article 121, paragraph 5 as potentially overriding Part 2, it would only apply to states parties which have not accepted the amendment in question. So it would not, for instance, apply to non-state parties. And we would have a situation where, let's say, nationals of a non-state party would commit acts of aggression on the territory of a state party that has ratified the amendment on aggression. The ICC would potentially have jurisdiction over these
as they do
incidents,
now.
But not, yes, no, well, jurisdiction,
I mean,
yes.
yeah, not
it
on
would
aggression,
also be
but
able
on
to exercise
other,
it. But if the same situation occurred with regard between a state party which has accepted the amendment and a state party which has not accepted the amendment, the ICC would not have jurisdiction over this situation. Thank you.
Thank you. Very good. Stefan.
Thank you. This is very difficult, and actually our topic here on its face is so technical that I'm really glad I'm on the panel and not in the audience, because I would really have a hard time following. But
that's why Michael comes
here,
around giving them papers to keep them
sitting
awake.
here, it makes it a bit easier, and so I'll also try to be brief and maybe just to point out that, again, even though all this sounds very technical and who reads the final clauses, and it's the last thing that is done when a treaty is negotiated, which I think is a questionable thing to do. This is very much about the big issues here. This is about power, about politics, about sovereignty. The ultimate decision that we take with respect to the amendment procedure will be part of the success or failure that comes out of the review conference. And when we started discussing in more detail the crime of aggression in 2003 in the special working group, we started talking about this problem at the beginning, and we said, wait, actually, let's not talk about this now. Once we have a consensus on the content of aggression, that's not going to be a big deal. Of course, because of the issue of jurisdiction, we're not there yet when it comes to consensus. But theoretically, if thanks to some brilliant idea that comes from an NGO tomorrow, how we can solve the issue of the Security Council, well, we'll agree on which procedure it's going to be, and it's going to be more a technical matter than a political one. But in any event, these options that are in here, they have to be agreed by the states parties at the review conference. And that is why, in the end, it is probably not so much a question, well, what's the exact legal interpretation, but what can we agree to? And I think that's just going to be a fact. I think it's going to be difficult to influence the voting of these delegations purely with legal arguments. They might think that this and that interpretation is legally correct, but we don't want it. And it's a sovereign decision to say, actually, under these circumstances, I don't want an amendment, and I will vote against or try to prevent prevent taking a decision on this. Also, the current amendment provisions are indeed a bit confusing, and to some extent, if read on their face, a bit difficult to understand, and then maybe even unfair. If you take 121 paragraph 5, the second sentence, and you have written an article about this and tried to read this a bit more reasonably, but on its face, this sentence is saying, well, you better become a state party before the review conference, because then you will have the privilege to say after the review conference, I don't like the solution we have on aggression. I'm going to shield my nationals and my territory from prosecutions on aggression. That is, you can say, well, that's a privilege of those who have signed up for it, but it might be an issue which we might have to address in one way or another. Maybe the Assembly of States Parties could, make a declaration on what is intended there. I think some of the states that are observing this very closely might not be content just having this out there and just having this potential discrimination looming in the future. And I would be actually very interested to hear if maybe those who have been in Rome have a bit about the background of this, if that was really an intended consequence or if it's just sloppy drafting in the end. Then let me come to another point, and it goes a bit beyond these rules of amendment, because in the end, when we talk about the different applicable rules of amendment, we are talking about, again, power and sovereignty. Who wants to be subject to this future regime, to what extent? Do you accept to be subject to a future Security Council decision of aggression? Or to the opposite, are you as a Security Council member comfortable being subject to the ICC, having jurisdiction over your leaders on this without having a say in a Security Council? What if you're a non-state party, etc.? And these issues of jurisdiction are, in my view, closely linked to the question of territorial jurisdiction and national jurisdiction that we have in Article 12. And Article 12 actually has been one way of limiting the court's jurisdiction, and there was also a political decision behind that, because there was only so far that states wanted to go in subjecting themselves to the jurisdiction of the court, which is why in Article 12, paragraph 2a, you have a provision that requires for the court to exercise jurisdiction that the conduct take place on the territory of a state party, or otherwise that the suspect be a national of a state party, except in the case of a Security Council referral. Now, I would like to link this to the crime of aggression and say the following scenario. Imagine you have a future where the Rome Statute doesn't have the crime of aggression on the books, and a non-state party commits an act of aggression against a state party. Now, my question is, what does this mean for Article 12? Because Article 12 says court has jurisdiction in case the crime happens on the territory, or the conduct happens on the territory of the state party. Can the victim state, that is a state party, in such a circumstance actually refer the case to the ICC, even though the aggressor state is not the state party? And the question therefore is in Article 12, so where does the conduct take place? Now, initially you would say, well, obviously it takes place on the victim state. That's where the aggression takes place. That's where the shooting takes place. However, I think one must think a bit about the way we have drafted the crime of aggression in the current chairman's paper, and whether that is actually clear enough here, because we have gone a long way in saying, well, the conduct of the individual has to be distinguished very clearly from the state act. The conduct of the individual in the crime of aggression is the leadership, it's leading the state into an act of aggression. And in all likelihood, any future leader, aggressor, will actually not even go on the territory of the victim state, but plan and initiate the act of aggression from his own home state. So the question to me is, actually, under the current drafting, if that would go into the statute, can we say with all confidence that the conduct in question actually does occur on the territory of the victim state? Or would a defendant be successful in arguing, well, I never left my country. How can you say that I committed a crime in a state party? There is no jurisdiction for the court. That's a question I want to put out there. It requires an interpretation of Article 12. You might involve some principles, etc. But it's not. I think it's not as clear-cut and as easy as in other cases. For example, if you take Charles Taylor being in Liberia, being indicted for aiding and abetting crimes that took place in Sierra Leone, because the primary crime took clearly place in Sierra Leone. It was the killing, etc. But here, the primary crime is, it's an intellectual crime. It's a planning, initiating, etc. So I just want to raise the question whether this is really clear in the text, which leads me to my final point. In case that is not so, in case you would actually have to conclude, wait a minute, actually the crime of aggression by its nature takes place, the territory is the aggressor state. That would have a tremendous impact, obviously, on questions of jurisdiction and on questions of amendment, and maybe even on question of the role of the Security Council. If you would argue that the crime of aggression, by definition, and you could even think about adding such a sentence if you think that would be wise to get a consensus. If you say that the crime of aggression, by definition, takes place in the aggressor state, that would, in essence, mean that you could have a mechanism by which each state can voluntarily submit itself to the jurisdiction of the ICC. I would assume that would be much easier to accept for Security Council members, not to have a Security Council give a substantive role, because leaders of those countries could not be subject to the authority of the ICC without their consent. Their country would still have to subject itself directly to the ICC. So here's a double question. Is, on the one hand, in the current drafting, is it clear where the crime takes place? And even if it's clear or if it's not clear, is that maybe a consideration for our future work on jurisdiction? And that could then also have an impact on which amendment procedure we choose.
Thank you.
Sorry for these really weird questions.
I'd like to take just a moment to kind of review some of what we said, and then open it up if there are people in the audience who I invited you all earlier, but if there are people who would like to ask a question or comment, I'd like to invite that. But just to clarify, a couple of things that Stefan said that struck me. At the review conference, people have to agree. It's like that poster that some of us have seen, "My mind's made up, don't confuse me with the facts." It really doesn't matter what it says on the menu. If people don't like the smell and they don't want to bite, and they don't want to order the dish, they don't want it served up, and they're not going to be in on it, they can always vote against it, regardless, if you will, of the technical argument that's being made as to what position is technically correct. So it's got to be something that's saleable as a practical matter. And if not, maybe people need to do some amendment. But it's conventional law. People have the right to be in or out generally. And that comes to the point that you were making about, is it fair to treat non-states parties, countries that didn't even want to be in on the Rome Statute to begin with, who said, no, we're not buying, thank you very much, have a nice time. Is it fair to now subject them to rules that would be more harsh than those who said, yeah, we're going to belly up to the bar and become, if you will, contractors to this contract, among ourselves as a treaty? Something we haven't talked very much about in this panel is the fact that the whole Rome Statute is premised on complementarity. In my mind, if we had an amendment, by the way, we've spoken mostly today about Article 121.4, which is how an amendment becomes effective. To become an amendment in the statute only takes 2/3 vote. It's not active, if you will, it's not effectuated legally, but it's in the statute on its face, listing whatever the Assembly wants to call the crime of aggression. And I could see a scenario where, in theory, countries might take such text and try to draft their own domestic legislation on it. As Astrid knows, there are how many countries today that actually think they have aggression on their books?
27. Why do they think so? And they have it.
27. Well, because if they look carefully at how those statutes define aggression, they may get a lot of criminal defense lawyers saying it's not with sufficient specificity to uphold a criminal charge. That's my guess. I'm only guessing. Not a criminal defense counsel.
I've recently heard the counter-argument. There's only one country that has a very explicit definition on the act of aggression in its national code. That is Croatia.
Who is that?
Croatia.
Croatia.
And I've heard just last weekend at a conference a Croatian law professor saying, well, my main criticism against this provision that it defines the act of aggression, because this you can't do in a national code, you need to interpret it in accordance with international law.
Well, that's very interesting. I think a lot of us would probably disagree that his domestic courts have to be looking to external jurisprudence if they have it on their own books, but I'm not a Croatian law expert. But again, I want to just bring our minds back a little bit to the complementarity issue. There are, of course, a lot of political questions there. Will a state, in fact, ever really try one of its own leaders? Well, if you had a regime change, in fact, most of us have probably seen or received emails suggesting that we might want to be involved in impeaching certain government officials in the United States today, and those emails have been streaming in for about the last 6 or 7 years, I suspect. Okay, well, with that, I'd like to open it back up to anybody on the panel or in the audience. Christian.
Well, there must be some law students here. And so just a warning, if you pursue this career, you're going to end up thinking that drafting the final clause is as exciting as having sex, to quote Roger Clark.
Close.
And you will admit so publicly.
I have to intervene. Your point being?
So, okay, I think it's clear the final clauses are problematic, okay? And we all have seen that Roger is still upset about them 10 years later. And rightly so, to some extent. Nevertheless, they are what they are now, and that's the final clauses we have to work with. In the end, I believe what Stefan has said really is the point that we need to keep in mind is what is going to work for us in the end. And Astrid has said, well, you can make arguments both for 121.4 and 121.5, and that's certainly true, and people have done that. Even though my question to Roger also is, what do you do with 5.2? Maybe I didn't hear what you said. Do you delete that?
I'm sorry.
5.2?
5-2.
Article.
What about it?
5.2.
Do you delete that?
No, you don't have to do anything about it.
Okay, so that stays in, so that's why it's not an amendment, right? Because the moment you delete it, it is an amendment.
Hang on.
Yeah,
Yeah.
but you don't
If
need
we were to change the language at all of 5.2, would it be something other than an amendment, or it would be an amendment in your eyes, Roger?
Well, if your position is you can amend 5.2 if you're the first person who agrees to the amendment, and then the second person, the third person, it's crazy if you look at it that way.
The question I'm asking is any change to the language, deletion or addition to Article 5.2 called an amendment in your mind, or it's something different?
What's not? What
You're
depends
saying
what
it's
you do
not an
with it.
amendment.
It depends what you do with it. Defining aggression is not an amendment. If you want to take 5.2 out of there, if you want to change the treaty,
Is that an amendment?
conceivably, yeah.
Conceivably.
Yeah.
Can you say yes or no?
No, because
wanna clarify.
I think it's subject to the same problems.
Okay.
It was drafted the last couple of days without anybody really
Okay,
thinking
so
what
we don't
they'd
really
do.
know among us.
Like,
We'll let
I
the
mean, that's
judges
why I think
decide.
it's impossible to try and figure this out as an intention.
I see. Okay.
Because the stuff was done, as
Okay.
I say, by the
didn't mean to
unseen
cut-
hand right at the end.
I didn't mean to
Sorry.
cut Ambassador Venevitz. Was there more? There was more, I think.
Yeah,
you wanted
there's
to
a
say.
lot more.
All right.
Sorry.
So I think the way we have to think about it is because Astrid has said, okay, we can argue both ways. Fine. Okay, that's what you have lawyers for. Which is in some ways great because then you have an option. So what is the better option? What I'm surprised that nobody has really addressed is what's going to work in the ratification process. So if you take 121.4, you need 7/8. And as was pointed out, before you have that, nothing happens whatsoever. Does not enter into force for anyone. Okay, so you need 7/8, which is today 95 states. By the time we are in, wherever, at the review conference, let's say we have 120 states parties, it's 105 states. Do you know how long that takes? That takes 10 years. Okay, fine. If you can wait that long, that's fine. I mean, there's no quick fix here anyway. We all know that. But that is a very long time. More importantly, though, if it is a solution that is a controversial solution, you might never get there. Because it would be controversial because the P5 do not like it. And these are states that go lobby around the world and ask people not to ratify certain things they do not like. So you might end up with a decision that was made at a review conference that has absolutely no practical effect. Okay. It is a worst case scenario in a way, but it's absolutely not impossible. On 121.5, and that brings me to Cherif. You know, I'm not from a part of the world where Swiss cheese is looked down upon. So I think that the cheese with the holes is certainly better than the cheese that is dangling somewhere. That is, I mean, to my mind, that is absolutely no question. What you have in terms of ratification process, projected ratification process under 121.5 is an incremental process that is probably also slow, but it can go step by step. And to say the world is not ready for aggression in the Rome Statute, I think is almost the same as saying it, and it won't be in the future. I don't know if you've seen the movie The Contender, that is about the vice presidential candidate. And there's a great line in it, and the line is, "You're the future of the Democratic Party, and you always will be." So, and I think it is a bit the same thing. I'm almost done. Sorry.
No, we're interested.
No, I'm glad. No, just the one final point. Now, in terms of striking a balance and finding a deal along the lines of what I have tried to describe over lunch, you need something on the role of the council that is not the exclusive competence of the council. Okay? I'm very convinced of that. That means it is not a solution that the P5 do favor, which in my mind then also means that you have a much better chance of getting this agreed if you do combine it with 121.5.
Just again to paraphrase, although it really doesn't need paraphrasing, if the P5 feel, I think I'm paraphrasing what we've just heard, that if the P5 feel there is any circumstance conceivable under which they could have the crime of aggression shoved down their throat by 7/8 of the assembly actually ratifying, and therefore it being effective as to everyone, they will object. But if they know that it doesn't have to be applicable to them because the effective applicable rule will be 121.5 that says it doesn't apply to anyone unless they say, me too, then they may be willing to live with letting it get into the statute. Fair paraphrase? Okay, thank you. I don't think we have very much more time unless Mike Scharf tells me we do. What time are we ending this session?
Well, originally we were going to be at 5:15, but I saw a lot of worn out looks, so I was hoping around 5, but we could take 2 more questions.
Okay, we have time for 2 more questions.
I wanted to just come back to something Stefan said at the beginning. And that is the way of posing this as either a sort of matter of politics or of legality. But I'm not sure that that's the right way to pose it, because in some ways, since we're talking about a contract in many ways, there's a question if there really is a problem in the drafting. Then there's a question about whether there really was a meeting of the minds to begin with that would bind anybody, and that's a strictly legal question of contract interpretation. So I guess the question I would continue to think about this in strictly legal terms. The question about whether it's not a question of whether the states cooperate as a matter of politics, but whether they will actually extradite to The Hague, and they might say we're not going to extradite to The Hague if you go a certain way on this, simply because we don't think we were bound. And the reason we don't think we were bound is because it was so complicated and so messy that there was no meeting of the minds, and that's just a straightforward legal argument.
So who wants to react?
I guess since it was my initial point, I was I think just trying to make kind of give a picture what the approaches of people in the working group. And in the end, if we have a consensus or decision by the working group that is based on either 4 or 5 as amendment procedure, I think this panel has also shown there are good arguments for both. So the final outcome would not be not be frivolous, but would be accepted by all, and then I think it would be very difficult to argue to go so far that then maybe national judges would say, well, this whole amendment procedure is illegal and therefore we are not bound. I think that consequence would go too far for that problem we admittedly have here. It's just not really black and white enough, I think, for a national court in the end to make such a conclusion. I think that would be really overreaching. But
Roger, did you want to add 30 seconds to that?
Yeah,
or
30
not?
seconds.
Okay.
Look, if you've got a legal problem in a context where you're talking about putting people in jail, criminal law, and assume we adopt solution A, sooner or later some criminal defendant before the ICC is going to argue that it's null, void, of no effect. You should have used solution B. I think it's Larry's point. Forget what a national court is going to do. And to be litigated, there's a juridical risk in a political solution. Now, we may agree to run that risk. We may say, okay, so we'll try it, and if it fails 20 years from now, which may take that long, so be it, and then we'll deal with the politics then. I mean, that's a conceivable solution. It's not one I'm very comfortable with.
I'm not personally uncomfortable with it, but we have only a very limited period of time. I know that Mr. Manson had a comment that he wanted to make or a question he wanted to ask, and then I'm going to give the mic to Cherif Bassiouni, and then we're going to be finished.
Given the limited time, if it's okay, I shall address you in my usual fashion.
Limited time. You have 60 seconds.
With your permission, then, can I take an extra 30 seconds to make a comment?
90 seconds. It's
to
running.
There is, can I come to the aid of the learned professor, Professor Clark? I don't know, Professor Bassiouni. It's obvious to any lawyer that this was written in the heat of a Rome summer, because if you actually look at the first 6 words of Article 1215, it is a misapplication of the conjunctive participle. It says any amendment to Articles 5, 6, 7, and 8 of this statute shall enter into force. Clearly meant to say 5, 6, 7, or 8.
that was the Secretariat.
Or you meant to say any amendments to all of those.
Rome has many distractions, Robbie.
So this wording is a nonsense to start with. If you're going to get all head up about it, you need to get it right to begin with anyway. I'm going to have to cut through everything else I was going to comment and say this. Yes, there clearly is an elephant in the room, Mr. Chairman, that you have alluded to, and which I think needed to be put right at the start of the contribution. And that is the deal which might be on the table here, the deal which ought to be available to be discussed, is whether or not a solution using the 125 mechanism, if we can agree on how to make it work and we can get over these technical problems, will assuage the concerns of the P5 about being able to have not only the definition but the jurisdiction without the exclusive predetermination of the Security Council. Can a deal be done between these two poles so that some compromise can be reached? And we are, as the ambassador has told us, in the territory of politics on this issue, not necessarily on the definition, but on this issue we have moved almost fully into the territory of politics. And as the review conference gets closer and closer, we are going to have to be more accepting of the reality that a compromise of a twin-track regime, where there are some states who are prepared to sign up to it, and other states who will only allow the amendment because they don't want to be forced into it, is going to have to be a reality faced. It's not one that international conferences like to, who always want to opt for consensus and universality if it's all possible. But that's the reality. And can I just conclude by saying this? The concerns which have been voiced today about the Security Council jurisdiction point that I've noted down, the politically motivated prosecution issue, the issue about the exclusively being competent under Article 39 of the UN Charter, and ultimately about whether or not the current threshold wording is enough to permit or outlaw humanitarian intervention around terrorism. This, as a mechanism, could assuage all those concerns if states who are not yet convinced that, as Ambassador Sheffer was telling us, frankly, the ICC judges have the legal competence to deal with these issues, well, then they stay out until they may be convinced. I would like to call this the suck it and see idea, because I am, at the end of the day, with Professor Ferencz Senior, who says maybe we've got to build this castle one brick at a time, but we've got to start building it a bit faster than we have now. Thank you very much.
Thank you, Mr. Manson. Thank you. Okay, with that, I will turn it now to Cherif Bassiouni to give a few concluding thoughts of his own, and then I know Michael Scharf wants to share some thoughts.
We are confronted with two choices, and the first choice is to find a way to reinforce the symbolic existence of aggression in the ICC statute without making it, to use a simple term, operational, without defining it, without developing triggering mechanisms, without putting it into effect. The other option is to try to operationalize it, which requires triggering mechanisms. It requires a definition. It requires addressing a variety of issues, ranging from such issues as were raised here about jurisdiction, the locus of where the crime was committed, what is the impact theory of jurisdiction, how do you establish individual criminal responsibility for decision makers, what are the elements of the crime, and so on. Bearing in mind that if you undertake this rather complex process, you are going to have, and this is not a qualitative judgment on one's predilection for Swiss cheese or not, but you are going to have to accept the fact that you are not going to have an even regime. You're not going to have a regime that will evenly apply to all state parties, to non-state parties, to individuals. Consequently, having such an uneven legal regime, in my submission to you, undermines a very fundamental element of criminal justice, and that is that the law is applied in a consistent way and in an even way to all parties. The moment you create a disparity whereby some will be able to claim that they have not acceded to the 121.5 requirements, or who have found any particular escape hatch, is going to undermine the legitimacy and the credibility of the institutions in public perception. This is the crisis that the ICC is facing today, as Elizabeth mentioned earlier, in terms of the reactions of countries that are saying this is only directed against a number of African states. And these comparisons are made consistently. Why Uganda? Why the Sudan? Why not Iraq? Why not Afghanistan, or whatever else it may be? So to then have a system which institutionalizes certain disparities as between those who have approved, those who haven't approved, the Security Council triggering in this case, not triggering in the other, the Security Council kicking the ball by default or by other mechanism to another legal entity, it is much too complex a system to convey to the general public in the world that there is a system of justice that they can relate to, that is consistent, that is equal, that is fair, and that applies to all in the same manner. I don't know, as a matter of criminal justice policy, if one is a legislator trying to legislate a particular crime in a domestic context, if you would really opt for legislating in an area that would be so fraught with difficulties in its application, and so fraught with issues of how it's going to be perceived as justice in the society. Because any undermining of the perception of justice for that crime and the politicization of that crime necessarily will impact on the other crimes. And that's, I think, what Mark was saying earlier. Maybe we have to go through a period of time where we have to coalesce, strengthen the perceptions and values regarding those three major crimes, and there will be another time to get to it. How do we do that, and yet at the same time reconcile it with what Ben was saying? You know, we cannot do anything that would implicitly discredit what was done at Nuremberg and Tokyo. How do we leave this still alive? I think we have to think of another way of doing it. And maybe the way of doing it is simply, as Christian was saying, you know, you opt for the provision that you require 7/8. You have it defined. You wait for the 10 years to pass. You have a sort of a maturing and ripening process that develops. And 10 years from now, if we reach the 7/8, maybe we have passed that stage. If we haven't, it can always be revisited. Thank you.
Okay, thank you. Michael has informed me we're out of time, so with that, I'd like you to join me in thanking our panelists, and I'll turn it over to Mike.
All right, first of all, note to self, next time I create a PowerPoint presentation, no hypnotically strange icon. Okay, a few concluding remarks. First of all, our colleague from Georgia, are you at the embassy? Yes, okay, so I thought that it was really an interesting moment when someone from the Embassy of Georgia in D.C. came all the way up to Cleveland to make a very important point. And the question and the point shows how very timely and real the issue that we've been debating is, and I thank you for that. My own thoughts on the deterrent questions that we wrestled with this morning and that Cherif brought up is when Cherif says, look, you know, maybe we ought to do this politically, maybe we ought to think about sanctions and the old traditional approaches to aggression, is that forgets that there is actually a function which I will use the vernacular and call lawfare. And normally lawfare is thought of as what terrorists do to try to level the playing field, but it can also be what governments do. And the way it works is if you indict a government, someone like Slobodan Milosevic, for the crime of aggression, and then you want to get the rest of the council members to impose sanctions, or to authorize use of force, like in 1999, it's a lot easier if he's been indicted because you now have the moral authority and the cohesiveness. And what was missing in 1999 and why NATO had to invade without Security Council authorization and really tip the apple cart about what is unlawful use of force was we didn't have that in advance. And so I do think that there could be a very important function for the crime of aggression and the ability to indict people that is linked to the realpolitik uses of sanctions and authorized use of force and other things. So we're not just talking about something that's of academic utility only. My third point is that this morning's panels highlighted both the prospects and obstacles facing Ambassador van der Wassers and his colleagues, what they're going to have to be facing with on the Assembly of State Parties. And the afternoon panels provide some novel approaches for the possible middle ground that the ambassador was seeking, and which we'll explore tomorrow in our experts meeting. And hopefully this really set the stage for a very useful and, again, very technical discussion among the experts who are staying around tomorrow. Let me, as a fourth point, ask how many of you ended up having a chance to read the Cleveland Declaration and sign it? Can you raise your hand? Is there anybody who didn't see that document, that it didn't make it to you?
Our panel didn't see it yet.
Okay, well, no, they circulated up there. All right, if you didn't sign it because you didn't see it, we'll have those available during the Rotunda reception for you. And I'm hoping that when we send along our Journal of International Law issue, which has the report of our experts meeting and the articles written by all of our panelists, that it will also have a lot of signatures on that document, which in essence just says, look, the time has come for the Assembly of State Parties to do something on this issue, and we really think that this is doable. We're not telling you exactly how to do it. Maybe we're giving you guidance and the other materials we give you, but let's get it done. And I hope you all will think about signing it. And Cherif, interestingly, despite his cautiousness and his skepticism, it was your idea to have the declaration, and you drafted it. So obviously, you think that there's some merit to this. Finally, I want to say a couple of thanks. I want to thank the student editors of the Journal of International Law who have been running around with the microphones and who will be publishing the articles from this and who do so much for us as partners. I want to thank my staff, Nancy Pratt and Alice Simon, who you saw at registration and who do so much to make all of this work. My colleagues on the faculty and administration who came and participated. I see Bob Strassfeld out there, and there have been several that have been coming through. And especially all of the speakers who have traveled from all over the globe to join our dialogue today and participate in our experts meeting tomorrow. And please now thank everybody by showing your applause and then joining me for a very informal and an interesting post-conference dialogue with whoever you want to at our reception around the corner. Thank you all.